Madam Speaker, friends and neighbors in the House. This resolution puts me in a very difficult position. While I'm not nearly as eloquent as Representative Winschittle or Representative Orth, I too revere the Second Amendment. And I strongly support Iowa joining 44 other states in incorporating the Second Amendment language in our Constitution. However, I have strong reservations about forcing judges to apply the strict scrutiny language to any and all gun-related legislation. If we pass the strict scrutiny requirement, Iowa would be in a very distinct minority. Of the 44 states that include Second Amendment language in their constitutions, only 3, Louisiana, Alabama, and Missouri, include the strict scrutiny requirement. Interestingly enough, no additional states have seen fit to add this requirement. In fact, in the past few years, adding the strict scrutiny requirement has been proposed and rejected by legislatures in 8 states: South Dakota, Oklahoma, Illinois, Minnesota, Montana, Indiana, Florida, and Tennessee. 6 red states and 2 blue states. Why, you may ask, are other states not requiring strict scrutiny? Number of reasons, I believe. Number one is the expense. The 3 states that require strict scrutiny for firearm legislation have become testing grounds for challenges to existing regulations, an expensive experiment for taxpayers. Laws that have been challenged at considerable expense to the taxpayer include the following: felon in possession laws, a state law imposing a sentencing enhancement for the use of a firearm during kidnapping, a law prohibiting the possession of firearms while distributing drugs, and a law prohibiting possession by parolees with felony convictions. State expenses in litigating these cases has been substantial. An audit from the Missouri Auditor's Office estimated costs to the state in the millions of dollars. When Tennessee considered and rejected a similar strict scrutiny proposal, the fiscal note found that additional challenges to firearms laws would cost the state $100,000 per suit. Criminal defendants have used this amendment to bring up numerous frivolous challenges, clogging already overburdened courts. Another concern that's been raised is public safety. In addition to resulting in expensive litigation, some of these challenges have resulted in laws or criminal trials being put on hold. In Louisiana, a judge halted the trial of a felon who was caught riding in a car with a .40 caliber Smith & Wesson and an AK-47, determining that the state's felon in possession law was unconstitutional under the strict scrutiny standard. Fortunately, this and other similar decisions were corrected on appeal, but not until the cases made their way all the way to the state Supreme Court at considerable expense and continuing threats to public safety. Another concern is treating the Second Amendment differently from our other Bill of Rights. Varying degrees of scrutiny are applied to all the other fundamental Bill of Rights protections. The Fourth Amendment is the most obvious example. Search or seizure has to be reasonable, not necessary to serve a compelling state interest. The Eighth Amendment bars cruel and unusual punishment, but doesn't require the government to justify the punishment as necessary to serve a compelling state interest. And reasonable time, place, and manner restrictions are placed on speech in public areas where the rights of the speaker may come into conflict with the rights of others. Requiring strict scrutiny for the review of all firearm legislation fails to recognize that there are a wide variety of matters touching the Second Amendment that call for different levels of scrutiny and fly in the face of established court precedent. In the landmark Heller decision recognizing individual Second Amendment rights, the U.S. Supreme Court rejected the idea that strict scrutiny should apply to all gun laws. In fact, Justice Scalia's opinion identified many reasonable gun safety laws, like those that prevent dangerous people from accessing guns and keeping guns out of the hands of felons, as presumptively lawful, a very different standard from strict scrutiny. I know that Representative Winchittle is very concerned about the right of self-defense and defending yourself in your home. Well, we all are. But the courts have already determined that any law burdening the fundamental, inalienable right of self-defense in the home is subject to strict scrutiny. But as we move outside the home, intermediate scrutiny, which is also a tough standard to satisfy, is appropriate because public safety interests merit increased protection. Consider some of these areas. Permit requirements for people carrying handguns, openly or concealed. Minimum age requirements for purchasing and carrying firearms. Prohibition on the possession of guns by felons and domestic abusers. Sentencing enhancements for the use of firearms when committing other crimes. These don't have anything to do with the inalienable right of self-defense. These are public safety measures, and there's no reason to justify the necessity of applying the strict scrutiny standard to these other areas. Finally, I firmly believe that while almost all Iowans strongly support the Second Amendment, that they also support reasonable legislation recognizing public safety concerns. This strict scrutiny requirement would tie the hands of future legislators, preventing them from responding to changing needs and circumstances. While I support enshrining the Second Amendment in the Iowa Constitution, I wish we were not including the strict scrutiny requirement. And I share Representative Orth's concerns that this could have a very unfortunate impact when this matter, if and when this matter comes before the voters in 2022. I hope that in the event it does become before the voters in 2022, that we will have a full and vigorous debate, and I trust the people of Iowa to make the appropriate decision. Far be it from me to prevent them from having that opportunity. I just simply wish that we were bringing them a better piece of legislation to make their decision on. Thank you very much.
Chair recognizes